that's one. If there's 14,
I just need to deal with the disclosure application next. Before I do, there has been a complaint about the way in which I characterised Mr. Hughes's evidence just before the lunch adjournment. Your Honour will recall that there was an issue about why the Section 68 challenge in London had been withdrawn.
Yeah.
And the explanation given was because of the amendment to the award, and I said that was false. It's been suggested that I have thereby accused Mr. Hughes of something nefarious. I said, when I made my submissions, that I wasn't accusing Mr. Hughes of anything. And if I gave that impression, I can only apologise. But I had thought that I was sufficiently clear on that. And if I'm not, then I make it clear.
Well, I certainly understood you to say that there was no criticism of Mr. Hughes. He said what it said on instructions to start this.
Yes. Well, I felt it important to raise that again now, simply because the point had been taken against me. That somehow I'd accused him of something. That's certainly, I mean, it's impossible to see how he could know what the intentions were. He wasn't involved in the case at the time anyway, but there we are. So I certainly don't accuse him of anything. Having dealt with that, I will deal with the disclosure application. I need to take Your Honour very briefly to three cases, and we'll look at those very shortly. I'll do them in order, but other than that, I hope I'll be done in 15 minutes. So I rely, in support of my disclosure application, on everything effectively that I've said. There's only one further factual point that I rely on, and it's the press reports reporting conversations with Dr. Hourani about the way in which the KRG's dealt with its assets. I'll come on to that in a moment. But factually, ultimately, there's a very large degree of overlap between the alternative service and the disclosure. On my application for disclosure, the way it's put, because it was anticipated that this application would come on before the substantive merits hearing, any set-aside application of the order. But now that we're here, the effect of Your Honour's dealing with my own friend's application to set aside the order is that if it fails, then we'll be in a situation where this court can enforce that order. And so I put my application on two different bases. One is this application for a disclosure order, which could be made in support of which could be ancillary to a freezing order. And the other is simply in exercise of the court's powers to assist in the enforcement of one of its own judgments. So I'll deal with them in that order. The Pugachev case is the one which explains how the court exercises the power that it has. That's in Authorities Bundle 3 behind tab 58. The relevant passages of paragraphs 49 to 52. So on page 176, if Your Honour has not already read those, then it would be worth just reading down to the bottom of the page. Please. Yeah. The only other bit of this case I refer you on to paragraph 55 over the page, just the first couple of sentences. Must not lose sight of the fact that at this stage of claimants are only asking for information. In order for the provision of information is far less intrusive than an order which prevents them from dealing with assets. So that is what I'm doing. I don't need to persuade Your Honour that I have grounds for freezing, but I do need to persuade Your Honour that there are credible grounds for making an application so advised. So that obviously does necessitate some consideration of the general power of the court to grant freezing or relief. So I clearly have a good arguable case. That's the first part of that test, because I have awards. So the question is whether or not I have credible grounds, if I was so advised, if my client was so advised, to advance the position that there is a real risk of dissipation. Yeah. And my primary position on that application would be that the defendant has shown form. That is a particular issue that was dealt with in the Bosmar case, Bosmar and ETA, and one finds that behind, this is the second of three authorities, behind tab 9 in bundle 1. Paragraph 14.2. Page 4 of 9, Your Honour, towards the bottom of the page. Paragraph 14, this is a decision of...
Which tab?
Tab 9. Number 1.
Yeah.
Yes. Tab 9, page 4, paragraph 14. This is a decision of Sir John Chadwick, who is the Deputy Chief Justice. Paragraph 14 sets out the relevant legal principles and talks about real risk of it being unsatisfied, and then 2. So 1 and 2 are alternatives. And so if you want to just read a little relevant 2 in the citation from the case, and also 15, including the citation from that case, please. So if you want to see at the bottom of paragraph 17, the last couple of lines, these proceedings were commenced in March 2015. They were met by an application challenging the jurisdiction of the court. And so that's what happened in Bosmar. And then what happened subsequently, sometime later, was that on the 19th of January, this is the next paragraph, the legal representatives wrote withdrawing the application. And that was sent 6 days before a 2-day fixture was due to be heard. And the only reason given was a change of mind leading to the abandonment, for the change of mind, was the Court of First Instance ruling in the DNB Bank case. And Sir John Chadwick considers that and then rejects it as being the possible explanation, mostly because it wasn't until much later that the application was withdrawn. And then he recites some of the evidence and says, ultimately in paragraph 20, that he was entitled to draw the inference that the defendants made that application and never intended that it would be heard. That's at the bottom of subparagraph 3. The only inference that can draw from circumstances which ceased to exist the claims the defendant was not, never had been interested in adhering on the merits, interested in delaying the point at which it would be required to pay the claim or see it. There's no reason to think that this desire to frustrate the claimant's rights to be paid will have changed. And in those circumstances, paragraph 22, and he talks about criticisms of the evidence and says that the way he puts it is, he says in 21, I'm satisfied that the claimant is entitled to take review, that in the course of pursuing the defendant's various applications, allegations were made and statements were advanced in evidence by the legal representatives of the defendant in their legal statements which are inconsistent with the true position at the time, and that must have been appreciated. Obviously in this case, as I say again, just in case it's ever given to me, I'm not saying, of course, that Mr. Hughes knew that the statements in his witness statement were false. Of course he didn't. I don't say that, but I say that KRG knew that, and so we are on false here. Paragraph 22, in those circumstances when no hesitation in accepting the strong grounds of belief, this defendant, in that case with the assistance of legal representatives, has been prepared to adopt whatever tactical step if necessary to delay and defer resolution of this matter. So that was what ultimately justified a freezing order. So I say that there are credible grounds in this case, on the basis of which, if so advised, my clients would be entitled to apply for a freezing order. In addition to that point, I have these other circumstances that I have relied on in relation to Service Out, which are the campaign of stringing out the arbitration and enforcement, coupled with financial strangulation, the abuse of authority in the KRG, and also that specific discrete point. I also have I also rely on the defendant's own admissions about its own tactics in relation to a dispute it had with with the federal government of Iraq. And I say there is evidence that the KRG has hidden assets before. It has restructured oil trades. It has even arranged ship-to-ship transfers of oil, all to avoid detection by the federal government of Iraq. And it's said that this is all based on speculation and press coverage, but in fact, that comes from a report of statements made by Dr. Hourami himself, in effect boasting about his success in evading detection. I don't think we necessarily need to go there. That comes from a report dated November 2015. I'll give you one of the reference, bundle E2, tab 33, pages 773 to 775. Part of this appears to involve arranging very significant prepayments for oil, and that of course makes it much harder to attach any debts owed to the KRG because the debts are paid in advance. So if one wants to pursue third-party debt orders, for example, it becomes harder when the assets have been paid for already before they leave the KRI. So that may or may not be part of the plan. The report in that case said that the one I just referred to says that the revenues of the KRI are something like 800 to 850 million US dollars a month. Mr. Benson, from a different source, puts it at $500 million per month, something like that. I can't say that that is an accurate figure or not, or precisely accurate. However, there is evidence to that effect in bundles, in particular Mr. Benson's statement and the documents attached to it. Despite this, the defendant says it can't pay. And the reality, I suggest, is that, or I would suggest on an application for a freezing order, is that paying the claims is just not the priority. Other debts, other obligations are being preferred. And that has long been the position, was the position noted by Mr. Justice Burton and by Lord Justice Briggs. So my short position on that is simply that we ought to have a chance at this stage to look for assets, and if we can find assets which are available for execution, then this jurisdiction will allow me to help us do that. My learned friend calls the order that I seek draconian. It isn't. It's not. At least it's not the same. It's not in the same class as the freezing order. That was the point made with the church. And I would also note that in this regard, the KRG has in its evidence given, in effect, a sort of summary, potted explanation of its financial position. It's by no means a sort of full and frank explanation. So in effect, it's saying, well, here's half an explanation, or here's a summary explanation. Trust us, we haven't got any money. That, I would suggest, is not it's not terribly helpful to say, here's partial disclosure, so you don't need full disclosure. The second point on this, the second line of attack from my side is that, as I say, the disclosure application was made at a time when it was anticipated it would be decided before the set-aside application. Once the court disposes of that application, it can make a disclosure order anyway in support of enforcement. The authority I rely on, this is the last one, is in Bundle 2, D2. It's the Cruise City case, behind tab 41. It's the very final paragraph of that judgment. Judgment of Mr. Justice Field as he was. There was a big issue about whether or not Masri number 4 prevented the claims from getting this sort of order from against the defendant. Masri 4 is about summonsing officers into the court, and Masri 4 said in the Supreme Court, well, you can't do that unless the officers are already subject to the jurisdiction one way or another. They have to be present. They can't be summoned in. And Mr. Justice Field said, well, that doesn't interfere with my ability to make orders against the defendant. Yeah. The defendant is subject to the jurisdiction of the court. That's paragraph 31, where he says that. And the test he applies is whether the order sought has the potential for materially assisting the claimant in enforcing the awards. He says, and of course it's got to be just and true. The defendant should always provide disclosure, provided verified by the proper officer of their assets welfare. So in a way, doesn't really need to deal with the ancillary to a freezing order jurisdiction. You can just make an order to help enforcement, and that can involve ordering the defendant. It wouldn't be an order against an officer. It would simply order the defendant to make that disclosure. That's the principle. That's why I asked for the order. As to the draft of the order itself, Your Honour will find it behind.
Yeah.
That's the principle, as I say, and the reasons why I seek the order. The terms of the order themselves, Your Honour should have a bundle, ABC bundle. They were consolidated because they were really very small. It's behind B1. Before we look at the detailed terms of it, the point that's made against me in the skeleton argument, there is one point made about the scope of the order. I've described prepayments, and it's said that the scope of the order should not cover potential prepayments that may be made. That depends very much what that means. Certainly, if there is a current existing right to receive a prepayment,
yes, well, that's an asset, isn't it?
That's an asset. If there is some other sort of overarching umbrella agreement pursuant to which they're arranged, then those sorts of things are obviously some of the most important. And B, paragraph 1B is intended to be directed at. So there's 1A is the general order. 1B is directed at trying to identify prepayments.
Yes, arrangement entered into, so it's clear on its face there is a first past arrangement in relation to future receipts.
That's the sort of moment, yes.
Yeah.
So Benson 2 contains certain evidence about connections with DIFC and also with Dubai, and that's at Benson 2, paragraphs 79 to 81. If you want to know, that's D2, D tab 2, page 49. But just summarising it, the evidence is that the defendants are trading with international oil traders. There are very large prepayments being made, but the traders may also be paying the oil producers directly. And so there will be a question which arises about whose money that is when it's in the hands of the traders.
Yeah.
Is it a debt that's owed to the KRG, or is it money actually belonging to KRG that can be seized in some other manner? There are some of these traders, the evidence suggests, are registered in the DIFC, so the court may have enforcement jurisdiction against them. Some of them are registered in Dubai. Others will bank with banks who are registered here, and they may be open to the enforcement jurisdiction of the DIFC court anyway. And then, of course, there's a potential prospect for wider enforcement. The prepayments, I just make one final point. The prepayments are particularly important because, in part, they can be policed. Because the oil majors, the producers at least, have to declare their income. So insofar as there are prepayments in relation to them, then it may be that we can pick up any failure to comply. But in any event, the touchstone here is, does the order facilitate enforcement, etc. There was a point made in the evidence about the penal notice that appears on this order. And said it's inappropriate because you can't imprison anybody for breach of the order. My short answer to that is that's an issue for another day. That if that is right, then the court won't make a committal order. But there are other punishments available for breach of an injunction. Putting the penal notice on is simply a precondition to bringing committal proceedings. It should stay there just to keep that option open. I say that there's been a complete waiver of immunity anyway, but nobody's going to be sent to prison because that's on there. It's just a warning, and it ought to remain. On the issue of injunctions, the Court of Appeal took a fairly similar approach. Lord Justice Briggs basically took that line and said, if it's right that you can't imprison someone, well, that's going to be a matter for the committal process, but that's not for now. And the reference to that is paragraph 28 of Lord Justice Briggs' judgment, which is behind bundle E3, tab 86, page 1096. That's all I had to say about my disclosure application. Let's try any questions. And in fact, that's it.
Thank you very much.
I'll take the order of my responses to my learned friend's submission more or less in the order in which he made them. At an early stage of his submissions, he digressed somewhat on the choice of law provisions in Article 8 of DIFC Law 3 of 2004, we found his submission somewhat hard to follow, but it seemed to be that the law can only be used in relation to substantive matters. We agree with that analysis, and we also agree with his submission in his skeleton that the doctrine of state immunity is a procedural doctrine. He cites from Lady Fox's book at page 21, which you'll find in the bundle at G3, tab 85. We would commend that to my Lord to read, because it does inform really what this point is all about, as to whether or not the DIFC court is able to adopt the doctrine of state immunity, because all of this is, of course, in aid of Eleanor Friend's rather startling submission that the doctrine of state immunity doesn't apply either in the DIFC or the UAE. As to the latter, we will show that simply is and utterly wrong. So far as procedure is concerned in the DIFC court, it is our submission that the court is free to adopt whatever doctrines it likes. We have already taken you to the Protiviti or Protiviti case, but it bears, forgive me, revisiting in the light of my learned friend's submissions, and perhaps reading from the judgment a little more widely than perhaps I did in opening. May I therefore invite my Lord's attention to bundle G1 at tab 17. We looked at a couple of paragraphs. I'd like to look at the paragraphs either side of those I looked at in opening. Would you please go to paragraph 26, and my Lord will recollect that this case was turning upon the question of whether or not this court could adopt the doctrine of forum non conveniens. Paragraph 26, the court dealt with the submission that the proper application of the doctrine was a matter of substantive law, and so Article 8 of Law 3 of 2004 was invoked. The court, as we saw, in paragraph 27, that is set out. And the submission then was that the law of England and Wales applied. We looked at, I think, paragraph 29 in my opening submissions, and indeed looked at paragraph 30, where the Court of Appeal rejected the submission that the English law applied. But I'd like to take you on from there, if I may. So paragraph 30, I won't reread it, but it was found at the end that it follows as conceded, Mr. Atkin, that is open to this court to apply whatever FNC principles it regards as most suitable, because the court considered the doctrine to be a procedural doctrine and not a substantive doctrine. And then the court went on, even if the law of appropriate forum were substantive and not procedural, the European judgments regulation would, in my opinion, be of no application in the DIFC courts. This is because Article 4 of the regulation provides it applies in member states. 32. It being free to do so, in my view, this court should now take the opportunity to confirm that the FNC doctrine best suited to be applied in the DIFC courts is the English doctrine propounded in the Spiliada. And then that is explained, and indeed it is noted that the Spiliada has been followed in New Zealand and Singapore and Malaysia. There is reference at paragraph 33 to the Australian doctrine and indeed also to the US approach. Paragraph 34 looks at the Singaporean approach and also refers to Professor Briggs's writing in civil jurisdiction and judgments, and goes on to say, I think that this court should make it clear that Spiliada FNC principles will be potentially applicable where there is available another forum outside the UAE that is distinctly more appropriate than the IFC courts, even where the jurisdiction of the IFC courts is not exorbitant. This is, in my respectful submission, a clear indication as to the policy of this court in relation to what we were calling the common law, and particularly in relation to procedural matters, and that's all we're dealing with today. This court is free to adopt whatever common law doctrine it considers to be appropriate, and that's absolutely clear. And we see the way in which the Court of Appeal looked at the English doctrine of forum non-convenience and looked indeed at other jurisdictions and decided to, I use the word hesitantly, incorporate the English doctrine into the common law of the DISC. And we say there is a direct analogy with the doctrine of the immunity of states, and this court is perfectly free, subject to the points that we make about overarching UAE public policy, to adopt the common law approach to state immunity. I'll come in a moment.
But it wouldn't be limited to the common law approach, would it?
Well, no.
It can do anything we like, so to speak.
Yes, to adopt the public international law approach to sovereign immunity, indeed, my lord. Unless my learned friend is right that the law of the UAE effectively prohibits that. And so the law of the state does not include state immunity, but we say he is demonstrably wrong on that point, and I'll come to why in a moment. But I was trying to think of the same submission. My learned friend, I think in answer to a question that fell from my lord, was saying, well, if the common law is adopted, why should it go down the route of following legal in any event? When there has been adverse comment upon that. The answer in our submission are the reasons for the adoption of that approach by the Hong Kong Court of Final Appeal in the Congo case. I know that the Congo case was reported or heard before the NML case, but that doesn't deprive the reasoning of the court in terms of policy, which is what I want to show you, of its force. I'd just like to take you to one paragraph in that judgment, if I may, which is in bundle G2 at tab 42. We are at internal page 156, paragraph 392. And we do respectfully adopt this reasoning as the grounds for following what might be called the Old English common law position. They say, and they note, because Lord Panic, as one would expect, had already made the submission, that there had been criticism of the old common law position, and indeed we see in the previous paragraph that Lord Panic had indeed cited the Mann article to the court. So they certainly had in mind the criticisms of what we might call the Mig Hill approach, but they dismissed them, and they said this: we are with respect not persuaded that such a change would be wise or desirable. Whether or not a particular state accepts a commercial exception, the rationale of state immunity remains par in principle. Mutual recognition as co-equal sovereigns leads states to refrain from exercising jurisdiction over the foreign state concerned without the latter's questions. Questions of waiver only arise where the impleaded state does qualify for jurisdictional immunity in the forum state, or else there is nothing to waive. In such circumstances, the common law rule as to waiver is consonant with the elementary good sense by requiring an unequivocal submission to the jurisdiction of the forum state at the time when the forum state's jurisdiction is invoked against the impleaded state. Courts would be ill-advised to attempt to deem an impleaded state to have submitted to their jurisdiction when it has not done so explicitly by its words or conduct, and where its obligation to such jurisdiction is made clear in the recognition proceedings. Such a course is likely to be damaging to the relations between the two states and may very well be ineffectual in any event. So, my Lord, we do say that is an element, an eloquent, is the word I'm groping for. That's an eloquent statement of the reason why one should adopt the Miguel approach, and we do pray it in our submission that this court should follow that case if it feels able to follow the common law, and of course that case is still good law in England, no matter what has been said about it. But in any event, and as appears from that passage, Miguel itself is not a way of ducking the question of whether a doctrine of sovereign immunity applies in the UAE. Waiver, as is noted, does not become an issue until we know whether the doctrine applies or not. And of course, waiver would be irrelevant if the absolute version of the doctrine were to obtain in the UAE. If the restrictive version applies, we need to know whether the version permits waiver and under what circumstances. Of course, my learned friend persisted in his submission that no doctrine of sovereign immunity applies within the UAE. And I persisted in my submission that that is an absurd proposition. And indeed it finds no support in what is now the sole authority that appears to be relied upon. And we need to look at that, because my learned friend submitted in the clearest possible terms that that case found that there is no doctrine of sovereign immunity in the UAE. It does no such thing when you read it. So if we'd be kind enough to go to bundle G1 at tab 10, we go back to the decision of the Dubai Court of Cassation in the Sudan Bank case. And you need to be taken to a couple of parts of that judgment that you were not taken to. The first part is to be found at page 3 of the judgment. And we see what was actually before the Court of First Instance. So, upon hearing of the matter before the Court of First Instance, the defendant bank raised the following points of defence. I needn't trouble you, I think, with 1, 2, 3, or indeed 4. It's 5 that is the important one, over the next page, internal page 4. Before the Court of First Instance, it was said that the Dubai courts lacked competent jurisdiction to hear the claim pursuant to the Vienna Convention and the Riyadh Convention, because the Bank of Sudan was a public venture forming part of government entities of the Republic of Sudan. So the Court of First Instance was only concerned with whether or not the Bank of Sudan qualified for immunity under those two conventions. It was not concerned with a general doctrine of state immunity or the public policy of the Union. The Court of Appeal held that the Bank of Sudan did not qualify for immunity under those two conventions. And if you go to page 6, you see that the Court of Cassation affirmed the decision of the Court of Appeal, and the part that is relied upon at the bottom of page 6 is doing simply that. If we go to the bottom of page 6, given that, and since the judgment of the Appeals Court rejected the jurisdiction challenged by the bank on the basis that the bank does not enjoy immunity from its creditors for its commercial and banking transactions with other banks, this decision does not violate the law and the appeal from it is without basis. So, in fact, it was a much more narrow question that was before the Court of Cassation in this case. And at no point did the Dubai Court of Cassation address the questions of whether or not there is a general doctrine of state immunity in the UAE. The point was not argued before that court, and indeed we would say they would not indeed have jurisdiction to consider that matter, because that is a matter for the Union Supreme Court. But we say it is emphatically not the case that the court held that there is no such doctrine as the doctrine of state immunity under UAE law.
Why wasn't the point argued at all?
Well, I can't speak.
It's rather surprising, isn't it, if, as you say, the any argument appeared to be an immunity under the Vienna Convention and Riyadh Convention, you would have expected the wider argument to be taken.
Well, my Lord, I cannot speak for the competence or otherwise of the advocates that appear in that court. And I hope, I'm sure, at least privately, my learned friend to my left will agree with what I'm about to say, and my Lord, with perhaps greater experience of this jurisdiction, may also come to the conclusion that sometimes the quality of advocacy in some of the local courts is variable, if I can put it as delicately as that. So really, no doubt if my learned friend to my left were representing the parties, the point would have been taken. But there it is. I think it would be difficult to decide from the basis of speculating as to why advocates weren't taking a point that no such doctrine exists, particularly in the face of what is currently before the court, and I hope will subsequently before the court, in terms of learned writings about the doctrine.
Well, this is quite a bizarre situation, is it not, Mr. Black? Here I am on day 2 of the hearing, and I've seen no real authority on the point in either direction. I've seen a few articles which are very limited in what they say, and you tell me there's a textbook that you're only just going to produce in 48 hours' time.
Yes, but, well, less than that, I hope.
Well, indeed.
But, well, my Lord is enjoying an extended inauguration into the joys of practice in the Middle East. There are often many matters where one is still very much on a greenfield site. And of course, this is also a jurisdiction, and again, we must be very careful in not looking at things through common law eyes. This is a jurisdiction where the doctrine of stare decisis doesn't apply in any event. And also the reporting of cases there are no official law reports, so people have to scan the reports or they're passed hand to hand. So the absence of a case is not quite as significant here as it might be in a common law jurisdiction where you have reports and where people observe the doctrine of stare decisis. ultimately,
you're referring to Dubai rather than the DIFC.
I'm thinking to Dubai. Yes, yes, forgive me. Yes, of course. And the wider UAE. I mean,
Yes, of course.
There is no system of law reporting, and or at least not an advanced system. Some get reported unofficially. So, my lord, it is perhaps how can I say? I think one has to be sensitive to a different cultural milieu when one's observing and saying, well, is there a case on this or not? There may be, but we may never know that there is a case on it. That's the problem that practitioners come up against here time and time again.
But forgive me for asking the question bluntly, Mr.
Yes.
Effectively, what you're saying to me is that I can, in my position as a first instance judge here, decide what is the law of state immunity for DIFC. It's a procedural matter.
Sorry, my lord.
It's a procedural matter.
Yes.
It's within my compass to do so. I should obviously
Yes.
be guided by what I see as helpful comments from around the world and customary international law and so on and so forth. But subject to correction by the Court of Appeal and anything beyond, I can decide, can I? I'm, for the moment, ignoring your points that all this is a matter for the UAE court
Yes.
and no one else.
Subject to the overarching point about public policy and so on in the UAE. The answer to that question is very simply yes.
Yes. What a delight.
Well, again, another joy in on a greenfield jurisdiction where
Yes.
we are only 13 years old.
Yes.
Again, in a different cultural milieu, about to reach our manhood. Yes, there are many new points to be decided, and this is certainly one of them.
Yes.
But we do say that you do, unfortunately, have to look at the UAE position, and we do say that outside the DIFC there is a doctrine of state immunity. My little friend characterised Professor Al-Turki's work as confusing. We say actually it was far from that, and that was an unfair criticism. There was no confusion, and when you come to read it again, as I'm sure you will, you'll see that Professor Turki begins by noting as a matter of general international law that sovereign entities and their employees enjoy immunity both at the litigation and execution stages. He then descends from the general to the particular and talks about individuals under the Vienna Convention. There was nothing, we say, confusing about that at all. Equally, my learned friend suggested that the UAE courts only have recourse to Egyptian jurisprudence when considering provisions of the civil code derived from Egypt. My advice and our collective submission, based at least on the experience of 30% of us appearing before you, is that where the Dubai courts have not dealt with the matter, then the courts will look at Egyptian case law, and it's not just confined to perhaps provisions of the civil code that derive from the Egyptian civil code. My learned friend then, I think, went on to refer to Lady Fox's book at tab at G3, which is tab 85, and I'd like to take you to this, please, at page 392. And you'll see a section there, waiver and the arbitration exception. And Lady Fox says the extent of waiver to be deduced from entry into an arbitration agreement may be variously interpreted according to its scope. And she goes on to explain, in the interest of time, I will not read it to you, but I do ask you to consider it, because it also, she notes that there is considerable diversity of views amongst jurists and courts as to how far a state can be assumed to give its consent and waive immunity from execution in national courts. It is helpful in our submission, particularly in light of the answer to the question that my Lord asked and the answer I gave. These are matters where my Lord does have a degree of freedom of choice in how the doctrine is to work, subject, of course, to what the Court of Appeal may or may not say thereafter. But it is true that you do have freedom of choice. While we're in Fox, may we go back to page 353? And a part that, again, that my learned friend touched upon in relation to the issue of constituent parts of a federal state and how they are to be dealt with. And it's important to note that Lady Fox here was again setting out, as of course is appropriate in an academic work, the different theories that apply, and there were two theories here that she identified. She identified the view taken by the Australian High Court and the view taken by the French Court. I've already read this to you. I'm not going to trespass on your patience by reading it again. But it's worthy of note that the question of whether or not immunity applies only to an entity that is an actor on the international stage arises only under the French theory here, as we see from the second part of this, this passage. And sorry, I don't know if I'm saying something. Yes. Sorry, my learned friend's interruption was to draw attention to, as illustrated below in the English courts. The English courts, as I understand it, what Lady Fox has been saying, follow the French theory. So yes, you have but it's not a relevant consideration in the earlier Australian period, which is the point I was making. But can I just address the question of whether or not the KRG is an actor on the world stage, if I can put it that way, because it was my learned friend's submission based upon Article 110 of the Iraqi constitution. I won't take you to it again. It's in not dissimilar terms to the UAE constitution that we've looked at. It's behind tab 27 for your note. I didn't actually take you to the document that I relied on before, but I'd just like to show it to you, if I may. Could I take you to bundle E4 at tab 118? Sorry, it's E3 118. I do apologise for that. That's the wrong document. Sorry, I have a bad.
That's not right. No.
I have a bad reference. Forgive me. I'm after the Consulate General. on the website of the Kurdish Ministry of Foreign Affairs. I do apologise.
Sorry?
That's the last document. It's bundle street.
It's bundle
188. Is that right? It's 188.
It's 188. Oh, my appalling typing. Thank you very much. Yes, it's 188 in bundle 4. Thank you so much.
Yeah. Yes.
So
And what does this show me?
it shows you that the Kurdish regional government has a Department of Foreign Relations. We would also say that you are entitled. My learned friend said, "Well, there's a consulate, but the consulate doesn't prove that they undertake foreign relations. It just means that they're looking after the well-being of UAE nationals there." But, my lord, the other point that I would make, and it's one that I think you're entitled to take by way of judicial notice, is that the KRG is a very important actor on the world stage, as we know. And to suggest, we say, that it doesn't, perhaps de facto, involve itself in international relations, we say is out of touch with reality. And we do say that it does behave very much and is recognised very much as behaving as a sovereign entity. My learned friend then yes, and of course, that sorry, is that from? That's from the Fox book. Ah, okay. Yes, I've just reminded by my learned junior that when my lord looks at the section of Fox, and of course my learned friend also helpfully made reference to the English approach. The English approach is dealt with in Fox. If you'd be kind enough just to note it, I don't need to take it to you now. Page 354, and does refer to the New Brunswick case, Mellinger. So when we are getting to the English theory, the question of being on the world stage was...
I don't have page 354, do I? Not in the photocopy. No, I don't have it. Perhaps someone will donate me a copy of the book.
We will donate you... we'll certainly donate you a copy of 354. Okay, thank you. Thank you very
Well, the
much.
points of reply referring to pages, isn't it?
Well, that's anyway. My learned friend referred to all it does, my lord, is because my learned friend drew my attention, if I can put it delicately, to the English approach as opposed to the French approach that was referred to in Fox. But Fox deals with it and does refer to the New Brunswick case.
Yep, all right.
Thank you, my lord. Can I then deal? My little friend took my lord to the Pocket Kings case at
Yes.
bundle G3.
Yes. Well, that's referred to at page 354, which you probably see.
Yes.
Yes, Pocket Kings, which is where?
Sorry, my typing while listening to my learned friend is not as good as it should be.
Tab 67.
67, it's paragraph 21, thank you, and tab 67, it's paragraph 21 that I wanted to go to within. This was a paragraph, I think, referred to by my
Yes.
learned friend. And the point I'd just like to make in reply is that Pocket Kings, the reference to Pocket Kings did not go to the point that the KRG was exercising the sovereign authority of the state. We've made submissions about the status of the KRG under the Constitution, and we do say that the KRG fall under the definition of state under Article 2 of the UN Convention. My Lord then, my learned friend, took my Lord to Mr. Justice Burton's judgment, and forgive me if we go back to that. That is at bundle E2, tab 34, and it's at internal page 807. So, if I may, first of all, say that we do not accept that this case gives rise to an issue estoppel as contended for by my learned friend. Indeed, whether or not the doctrine of issue estoppel applies in the DIFC, one would have to determine whether it was going to be a doctrine that was substantive or procedural, and where the doctrine of the common law and his surprising submissions, but there it is. But we say that you need to approach Mr. Justice Burton's findings with some care. Mr. Montague-Smith accepts that they were not directed towards the common law when one looks at paragraph 37, but towards the Act. And we say that that is a difference that does indeed mean that one cannot rely upon this, even if the doctrine of estoppel, issue estoppel applied. And indeed, I'm not precluded by this finding under the SIA because it doesn't address the UN Convention. We say that the court must look at the question afresh. We accept that this court and my learned friend is not bound, equally not bound by the finding at paragraph 36, but we say that the logic at paragraph 36, which does find that the actions of the KRG were sovereign actions, is correct. And I'll come to that in a moment. But of course, if my learned friend is right that 37 gives rise to an issue estoppel, equally 36 must give rise to an issue estoppel too, that we contend that neither is correct. We did find his reference to the Holland case to be helpful. My Lord, I think, read that in a little bit of detail because you said that you had not hitherto been taken to it and were not familiar with it. It's at tab 55 of G2. And it was in particular the passage I think that my learned friend took you to in Lord Clyde's speech on page 1580 between letters E and G. Yes. And we say that when you combine what was said there by the House of Lords with paragraph 36 of Mr. Justice Burton's judgment, the logic of his finding that they were undertaking sovereign actions and the fact that they were dealing with a long-term arrangement for the exploitation of natural resources forms, as it were, part of the nature and character, using the words of Lord Clyde's speech, which gives rise to the fact that this was, in fact, a sovereign act and attracts immunity. We would say, of course, you have to sell the products, but that doesn't go to the essential character. This was not simply, as Mr. Justice Burton found, a contract for the sale of gas. It was much more than that in the scheme of things, and so he was right to find that it was a sovereign act, and one cannot simply pick and choose the individual incidents under the transaction and say, well, yes, this was overall a sovereign transaction, but part of the steps in that transaction are to be regarded as out with sovereign actions, if of course one is adopting the restrictive theory of sovereign immunity, and that always brings us back to the same question in the USC and what is the overarching policy in this country. And if I may come to that, I accept my learned friend's submission that the authorities in this court say that a reference to the USC must be on the basis of a case that this court finds seriously arguable. This case is seriously arguable in our submission. It is unique. It is dealing with something that is clearly stated in the Constitution. Foreign affairs are expressly reserved to the Union. It is clear in our submission, when one looks at the logic of the Court of the Hong Kong final appeal in the Congo case, that state immunity is a component of foreign affairs. My learned friend seeks to get round that argument by saying, oh well, the reservation at Article 120 of the Constitution is for legislative and executive functions, but that doesn't mean that the judicial function is affected by Article 120. We say that is a faulty analysis, and indeed that is why we took the court to the Congo case and the reasoning in that case in some detail. The Court of Hong Kong, the Court of Final Appeal in Hong Kong noted that a state will specify the appropriate organ of state charged with the task of determining whether, and if so in what form, the doctrine of state immunity obtains in that state. we would say that on that proper analysis, the UAE constitution reserves the question of whether the doctrine of state immunity and what form it takes in the UAE to the executive or the legislature. And indeed, far from being permissive in relation to the judicial arm of the state, it excludes the judicial arm of the state from formulating foreign policy. And we've seen in the writings, I won't go over them again, that different jurisdictions take different views. And of course, we say that in fact the situation in Hong Kong, where it was the central government in Beijing which was charged with that power, is analogous to the situation here, where the union is charged with that power. And this case does fall fairly and squarely, we say, within that situation, because this is not a case like the Sudan case, where there is essentially a binary question of fact. Does or does not a particular litigant fall within the protections afforded by a particular convention? Rather, it is a much wider question as to whether and what is the doctrine of state immunity in the UAE. And that, we say, is a matter for the Union Supreme Court. So far as my learned friend's arguments about the procedure to be adopted and whether it is triggered, we say two things in relation to the provisions of both the Constitution and the Union Supreme Court law we've already taken you to. Firstly, that if it is considered that the judicial authority law and the arbitration law allows this court to declare the doctrine of state immunity for the whole union, then in our submission they are in conflict with the Constitution and the jurisdiction is triggered. We do accept the reasoning in Fisk. That was a case which I had the unenviable task of arguing before this court that a provision of the arbitration law that I had personally drafted was unconstitutional. I was happy to be told it wasn't, but there it is. The second point is that the Union Supreme Court is the court that is charged under the Union Supreme Court law with the interpretation of the Constitution. And so there are two, if you like, two channels which take one to the Union Supreme Court. Well, I think that concludes the submissions I make on immunity, and I turn to the question of service.
Yes.
So far as service is concerned, my learned friend does not appear to be contesting the proposition that the Riyadh Convention is mandatory, but on the other hand, he introduces his own conditionality to its operation, which has the same effect. He made submissions based upon which law applies to the recognition of judgment and awards under the Riyadh Convention. We say those submissions are irrelevant to what are the clear terms of Article 6. Article 6 provides a code for service, not for execution. And it has never been, as far as we can ascertain, suggested that the Convention does not apply to originating process and to court orders. In this case, we're not dealing with non-legal documents and papers. The documents in respect of which we make our submissions are clearly documents which fall under the Convention and indeed require service. The whole point is about how are they to be served. And so it's hard to understand my learned friend's submissions on that point. He seemed to be saying, well, you must look at the practice in the Dubai courts, for example. This would mean that everything has to be served. Again, on instructions and information from my co-counsel, the practice adopted in the Dubai court is that written submissions are not served on the opposing party. The opening statement of claim is required to be served and is served under the Riyadh Convention, but not subsequent submissions. But that is a bit of a red herring, because on any view, the claim form and the orders in this case had to be served. And if they had to be served, then they had to be served under the Convention. But what my learned friend seems to be saying is, well, we don't like this Convention very much, it's inconvenient in this case, and this court should ignore, sidestep, and subvert it by dispensing with service or ordering alternative service. We submit that if the court adopts that dangerous course, it will be acting illegally and unconstitutionally in seeking to avoid a mandatory international convention. It will be a breach of the DIFC arbitration law, because the Riyadh Convention is one of the conventions caught by the Section 42, Article 42 of the arbitration law, because it deals with the enforcement of judgments. So the court would be in breach of that. It would be in breach of the founding laws of the DIFC. I have already taken you to those which provide that the financial free zone shall observe international conventions, and it will be in breach of the Constitution. And in any event, logically, my learned friend's argument is effectively a bootstraps argument, because it starts off from accepting that these documents must be served. But since the claimants don't like the convention, they say, well, you can order non-service of the documents, and then draws the logically fallacious point from that, saying, well, if you've ordered that they non-service, then they are documents that don't have to be served and therefore don't fall within the Riyadh Convention. It is a classic bootstraps argument. Further, his characterization of suggesting that I had argued yesterday that somehow there was a deeming of compliance with Iraqi law in relation to Article 6 of the Convention is mistaken. The point that I made yesterday, and I'll come back to shortly, was made in relation to Article 3 of the rules of the DIFC Court, not in relation to Article 6 of the Riyadh Convention. As far as Article 10 is concerned, Article 10 says what it says. And my learned friend kept on repeating the mantra, it can't be right. Well, it can't be right is not an argument at all. It's just saying effectively, we don't think it's fair. That is not a reason for ignoring the express terms of an international convention. Equally, reference to the New York Convention is irrelevant when we're talking about relations between UAE and Iraq.
Say to this extent that if the treaties give rise to irreconcilable positions, what's there?
I'm so sorry. Forgive me. I didn't catch.
If the treaties give rise to irreconcilable
but they don't.
position.
But they don't. My lord, I was going to come to that, but I'll come to it now.
No, we'll deal with it.
No, I'll deal with it now. They don't. The New York Convention, there is no irreconcilability there, because the New York Convention does not deal with the question of service, and it does not deal with the question of immunity. It deals with the recognition of arbitral awards. So let us assume, we'll take a hypothetical case and see if we can give rise to a reconcilable position. Because the UAE is a member of the New York Convention, and let us choose another Riyadh state, which is Egypt a member of the Riyadh Convention? So Egypt, yes. I know is a New York Convention state. So let's think about a position between Egypt and the UAE. So service has to be in accordance with the Riyadh Convention between those two countries. So we'll take an arbitration award which has been made against the UAE state, and it is being sought to be enforced in Egypt. Egypt is bound by the convention to recognize and enforce the award. Now, as part of its process, it will seek to have its court documents served on the UAE under the Riyadh Convention. That doesn't mean that the New York Convention is not working, because the New York Convention has already worked. Egypt is abiding by the convention and recognizing the award. The question is then whether or not the Egyptian court documents can be served and how they are served, and whether or not there is an immunity defense to service, and indeed an immunity defense to the enforcement. So, for example, the UAE could say, I'm going to short-circuit my assertion of immunity in the Egyptian courts by asserting immunity at the pleading stage altogether, or it could make a conditional appearance before the Egyptian courts and there claim sovereign immunity. But that doesn't mean there's a conflict between the New York Convention and the Riyadh Convention, because they're dealing with entirely different matters in my submission. And so we say that point is a fallacious point.
Maybe to look at the terms of the New York Convention. If the New York Convention requires contracting parties to enforce, and enforcement depends upon service, then you may very well get into a conflict, may you not? Outside recognition as such, I'm talking about enforcement, which is the specific.
Well, my lord, it has never been suggested the New York Convention overrides sovereign immunity, which is what the submission is in that case.
Well, then back to the waiver question. But assume we're wrong about that, and therefore we're in a position where enforcement is required as a matter of convention, of the New York Convention.
Yes.
Enforcement, as you say, depends upon service, and service can't be effective because, let's say, the Article 10 rights are then exercised by the receiving state.
But it is always possible for the receiving state to assert sovereign immunity by way of defence to enforcement under the New York Convention. And whether it's at the service stage or later, in our submission, it matters not. But it is a startling proposition. Sorry, my lord. Well, I would say it's a startling and novel proposition that you cannot enforce, you cannot assert sovereign immunity as a defence to the New York Convention. That would require some authority for that proposition.
Yes, but we're assuming for these purposes, on this hypothesis, the waiver is effective. We're assuming waiver is effective for both suit and execution.
Oh,
on this hypothesis.
If we assume the waiver is effective, that's an entirely different issue. Then if one waives sovereign immunity, then of course it's possible to serve and possible to enforce.
Well, say that under Article 10 of the ARB Convention, an assertion on the part of the receiving entity of the state, in this case, will trump any preceding decision of a court that there has been an effective waiver. It simply asserts it's not in our public policy interest to accept this for service, and we say we are sovereign even though any objective court anywhere in the world would decide otherwise. Now that's a problem, isn't it?
Well,
I mean, as I understand it, you would say, well, that's just the way life is. That's what Article 10 says.
well, ultimately I do, and beyond that, if that is a genuine problem, I'm sorry to be accused also of myself repeating a mantra, then that is a matter for the Union Supreme Court.
Or more probably for the executive or legislature.
Well, perhaps that.
The Union Supreme Court can't do much about it.
Well, the Union Supreme Court is charged under the Constitution with the interpretation of international treaties.
I understand that, but you say Article 120 simply puts all this in the lap of the legislative and executive.
Well, that is my submission. Where it goes is that, with the greatest deference and respect, I say it's not a matter for your lordship.
No, I understand. That's any question of who else it's a matter for.
Well,
on that footing. But
the route is pretty clear, actually, that the first port of call for this court is the Union Supreme Court. If this court finds that there is a potential conflict between two treaties of which this court is subject, then that does qualify for a matter which ought to go to the Union Supreme Court. They may say, well, we've got to refer it up or sideways to the other organs of the state, or they may say we can decide it. But I can't second guess what the Union Supreme Court might say under those circumstances. But what I can say is that under the law as it binds this court, it is our submission that if that is found to be the case, then that is the course that's the course that this court should take, my lord.
and is it the case? I don't think we've got actually the New York Convention as such in. Perhaps we have. Is it in the bundle here?
Well, I can almost recite its terms by heart. It is certainly the obligation.
Yes, it is. Tab 31.
So we are G1.
Yes, tab 31. We only have articles 1 and 2, I think. If anybody has any standard textbook on arbitration, will be in the back of the register.
Yes. What are we? Okay.
Article 5.
Well, Article 5 are the grounds for resisting recognition and enforcement. In fact, it's Article 2 here, which is the one that.
Well, that's shall recognise the agreement.
Yes.
Isn't there an article that says shall enforce, save for the following defences?
Yes, that's Article 5.
And what's the exact wording of that?
I can. Well done, thank you.
Thank you.
Article 5 is recognition and enforcement of the award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the competent authority where the recognition and enforcement is sought
proof of that, and that we have basically due process issues. But it's 5.2 that's perhaps the most important one. Recognition and enforcement of an arbitral award may also be reviewed
Yes.
if the competent authority in the country where recognition and enforcement is sought finds that
Yeah.
the subject matter is not capable of settlement,
Yes, all the usual. Yeah.
and B, contrary to public policy.
Yes.
That would certainly preserve the defence of sovereign immunity. So, my lord, but
What in any case where the state in question said claimed sovereign immunity, even if that had been decided against it already in a number of different places, simply as a matter of its own public policy, then say, well, that's that. Maybe that.
sorry. No, your question now. It is theoretically possible, my lord, yes, for a particular state to say, well, let's take China for example. So China says, and indeed it was very much the issue in the Hong Kong case. China, we have an absolute doctrine of state immunity, and our public policy is that any state is 100% immune from any enforcement. So it certainly, and indeed Lady Fox recognises it in the passages we've taken you to already, that it's a matter for the enforcing court.
Yes.
Ultimately, you'll recollect the passages that we took you to, where she was commenting, I think, on Article 7 of the UN Convention. So, yes, I think the answer to my last question is yes.
Yes, thank you. I'm sorry, I'm taking you off.
No, not at all. You've actually taken me precisely where I was, my lord, because it was the ultimate submission I wish to make, that if there is an interpretation issue here, then it is a matter under Article 59 of the Union Supreme Court law, a matter for the Union Supreme Court. Again, just for the note, you'll find that at tab 24 of bundle G1, internal page 12.
Yes.
My learned friend then went on to... Sorry?
It's 59. You mean 58.
Sorry, you interrupt. Let's have a look. Sorry, my learned friend interrupts me again.
I'm
G1.
sorry to interrupt. It's just...
No, you're right.
So you may be right, I thought. Article 59, the requests for interpretation of the international treaties and conventions which are brought...
But that's a new case, that's the point. I mean, that's the first time this has been said. But this is the first time.
I took you to an opening. I'm sorry, please may I continue without interruption? Article 59, which I took, my lord, to an opening, request for interpretation of international treaties and conventions that are brought before the courts in respect of an action being examined before the courts shall be referred by virtue of grounded decision by the court in accordance with stipulation of the first paragraph of the previous article. I distinctly recollect opening that.
It's not a position.
And so, as we say, it is a matter for the Supreme Court, if it is found that there is a proper interpretation of the convention. My learned friend then moved on to the question of ex parte orders against states. The short point we say is that each of the cases referred to, these were orders made under the particular domestic legislation of those courts, and there's no such similar legislation in the UAE. That doesn't help my learned friend in the broad picture, because it's accepted that these orders must be served, and that brings us back to service under the Riyadh Convention. He says that there is no need to establish jurisdiction. That is wrong in our submission, because once the state is served, it has the opportunity to dispute jurisdiction. And if there was no jurisdiction, the orders of the court will be discharged as having been made without jurisdiction. And that answers how courts make ex parte orders. They are vulnerable to be set aside on the basis that there is no jurisdiction to make those orders. Indeed, my learned friend began his submissions and then came back later to the issue of establishing jurisdiction and submitted that there is a difference between the DIFC courts and the English courts. And the DIFC courts are statutory, and therefore jurisdiction is not established by service. We say that's a bad point because it confuses what is meant by jurisdiction. The jurisdiction of the DIFC courts in terms of the matters with which it's empowered to deal is of course statutory. But jurisdiction in any particular case is established by service. And I go back to the very opening of my submission and pray and aid the passage from Dicey and Morris that I cited and I won't go back to. But if a party is not served in accordance with the court's procedures, including applicable conventions, the court will have no jurisdiction over that party and no jurisdiction to make any order against him. My learned friend then went on to deal with the treaties. We have addressed some of the issues, but he made the rather bold submission that the DIFC is not subject to the Riyadh Convention. We say that rather is contrary, as I've already said, to Articles 5 and 6 of Federal Law 8 of 24, and indeed the arbitration law, the DIFC arbitration law itself. It has never been doubted that the DIFC is subject to treaties made in the UAE. And we submit that the Barclays case is no authority to the contrary, and all that Sir Richard Field was saying in that case was that the question of enforcing judgments was not a matter of foreign affairs within the meaning of the UAE constitution, whereas as we pointed out in our skeleton and in our submissions, this case falls squarely within his definition of foreign affairs. The learned friend went on to refer to all the powers of the court in relation to service, dispensing with service and alternative service. We've addressed those. But, and I, even though I'm a slow typist, took down his words verbatim and said the court must have power to go round the Riyadh Convention. Courts can't go round inconvenient conventions, particularly by acting, as I say, illegally. He then went on to make what is essentially a jury point and said, why should the rules get in the way of enforcing this debt? But the claimants didn't have to come to this jurisdiction. They're trying to use the Riyadh Convention to get round the fact that England and Iraq are not parties to the New York Convention. However, they don't like the Riyadh Convention, and they say you should go round it. So we have a situation where a party is coming to this jurisdiction on the basis that a particular convention applies, and then asks this court to sidestep the express provisions of that convention, because perhaps they didn't foresee that all of the provisions of that convention might not be convenient to its purpose. As I said, there's no conflict with the New York Convention, and I've made my submissions on that. I think my learned friend submitted that the enforcement order need not be served at all on the KRG. I submit that that's a mistaken submission, and indeed contrary to the Cruise case that he relies on, which says that essentially starts the ball rolling in terms of enforcement. Finally, my learned friend went through the facts, and I can understand tactically why he would wish to make a jury speech, but the pretext of that jury speech was that you should exercise powers you do not have. You do not have the power to order alternative service, and you do not have the power to dispense with service in this case, especially for the illegitimate purpose of subverting the Riyadh Convention, because that is the essence of his submission. The Riyadh Convention cannot be sidestepped, and equally, one cannot sidestep the necessity to comply with Iraqi law in relation to the court's powers under under Part 3 of Rule 9 of the rules of the Dubai International, DIFC Court. There is nothing unfair in our submission about requiring the claimants to comply with Iraqi law, because this whole application and procedure before you is an attempt to avoid Iraqi law. The commercial reality is that the claimants entered into an agreement with a regional government of Iraq. No doubt they assessed the risks, including political and enforcement risks, when they did so. They decided upon arbitration in London. They have been successful in obtaining awards in the London arbitration, and they now try a circuitous route of enforcement through a jurisdiction that has nothing to do with the dispute. But they must take each jurisdiction as they find it. And frankly, and if I can be forgiven for also descending perhaps into the arena of jury points, the DIFC is not an international debt collection agency that will assist creditors, no matter how deserving, to get round international treaty obligations. You must apply the law as you find it. So finally he came to non-disclosure. We've made clear, I hope, in our submissions that the non-disclosure in relation to the enforcement order was as to the possibility of raising state immunity. Secondly, with regard to the Riyadh Convention, it is accepted that the court was not told that the convention was mandatory, which does not now to be seriously contradicted. And we say that the non-disclosure about the Riyadh Convention clearly goes as to service. Thirdly, as regards the non-disclosure in relation to the necessity to comply with Iraqi law, it is the case that that should have been informed of the court, to the court, that there was a necessity to comply with Iraqi law, and the court should have been satisfied that alternative service is permitted under Iraqi law. And that of itself should be enough to set service aside. And the question of Iraqi law should be argued inter partes. That is what we say is the effect of the non-disclosure. So, my Lord, those are my submissions in reply to my learned friend on my applications. If I may then move, if you'll bear with me for one moment, to my reply on the disclosure. It's always at this point your computer gives up on you for some reason.
So let me ask you a question.
Yes. Yes, my Lord. Sorry, yes.
You haven't made any submissions at all about the application of the rule in Abela and Badarani as interpreted in Marashen and Ivanchenko.
My Lord, I thought in my opening submissions, I did make clear, if I didn't, I apologise, that the point that we make is that you must look at the RDC. The RDC are clear in dividing up the procedure between service within Dubai and DIFC and service outside Dubai and DIFC.
Well, I understand that point, but supposing one could make an application of the same kind as was made in relation to the CPR, is there otherwise a distinction between the position in England and the position here?
Sorry, perhaps perhaps I'm not understanding my Lord's question.
Is the only basis for your contention that Abelard can't apply as a matter of principle here,
Yes.
the particular form that the rules take in the DIS?
Yes, my Lord.
There's no point that arises in relation to any difference in the way treaties take effect.
It is certainly the case that in the UAE, treaties are incorporated as the law of the UAE. I think my learned friend tries to get around that by saying, well, they then become civil and commercial and they're waived in the DIFC. In our respectful submission, that can't be right.
That doesn't work, does it? Because the DIFC, when it gets its powers for civil and commercial matters, specifically is bound by treaty.
Yes.
All the particular terms of number 8 of 2004. But the point I'm really asking about is this.
Yes,
In a context where there is provision in the treaty that service is only to be made exclusively in accordance with its terms,
Yes.
nonetheless the English court has felt able, adopting the Abelard line, to say, well, if there are special circumstances, we don't have to worry about that.
No,
We can go for substitutes.
I'm sorry. It's that. I'm sorry. There were 2 points on. I was thinking about the wrong Abdullah point in that case. Forgive me, my Lord. I do not accept that it is possible where a treaty like the Riyadh Treaty is binding to sidestep it in exceptional circumstances. It is absolute in our respectful submission.
And what's the reason for saying that, as compared with the situation which arose in Marashen, for example?
The reason for that is because the DIFC isn't, because it does not. The treaty becomes part of UAE law, and we say that it is not. And that part of UAE law is not a part from which the DIFC is exempted. And so the DIFC is bound to observe that treaty in its terms, and subordinate legislation, namely the RDC, and indeed the judicial authority law, cannot override that UAE legislation. But if there is a conflict, sorry to come back to it, but if there is a conflict between an Emirates legislation, i.e. that which governs this court, both the judicial authority law, which is Dubai law, and the court's law, which permits the RDC to be made under it, if that is in conflict with another part of the law of the Emirate, then that is to be resolved by the Union Supreme Court.
So, in fact, in answer to the question I asked you earlier, there is a material difference, you say, because treaties do not automatically form part of English domestic law.
No.
But they do form part, you say, of DIFC domestic law.
they automatically form part of the UAE law, and the UAE and
Yes, but by transfer, so to speak.
well, it's not by transfer. We are in the UAE.
But by lack of exclusion.
Correct. By lack of exclusion. And being a federal state, of course, you start at the top, constitution, start with federal laws, and then the units of the state have the ability to disapply. So, for example, the Emirate of Dubai has its own court system, but only 2 emirates do. The rest of them have federal courts. So there are exceptions from certain of the legislative provisions, but there is no exception here, and so it percolates all the way, if I may be forgiven, down to the DIFC. I don't mean to be disrespectful to the DIFC in any way, but if there is a waterfall or a cascade. Sorry, there is one further point that I'm just reminded by those on my left, which arises from a provision of the Supreme Court law, and Article 33 of the Supreme Court law states that the Supreme Court only shall have the jurisdiction to adjudicate the following matters, and Item 6 is explaining international treaties and conventions based on the request of one of the Federation authorities or member emirates, or if such explanation is a subject of dispute in an action offered before one of the courts.
Where do I find that?
That is in bundle G1, tab 24, at pages 7 to 8.
Yes.
Well, I think I can deal briefly with my own friend's disclosure application. The difference that appeared between his initial submission, the skeleton, and those in our skeleton appear to have disappeared. And it seems to be common ground that the test is there must be credible grounds for the making of an application for a freezing order, if so advised.
Yeah.
We, in our skeleton, deal with the question of whether or not there is credible material for making a freezing order. We submit that the claimants have failed to establish that. We refer to a decision of Mr. Justice Eder in the electromotive group case, and where he set out or summarized the relevant principles. And can I just, I'm sure they're very, very well known to my Lord, but I hope you'll forgive me for trespassing by just taking you to what Mr. Justice Eder said in that case, because we say they're not satisfied here. It's behind bundle G, in bundle G2, behind tab 51. We only do this because of the way in which he puts it is perhaps a particular relevance in the circumstance of the present case. We need to go to paragraph 33, little I. Unfortunately, the report is not paginated. Little I is best located by finding on the, I'm grateful. So he summarizes the provisions, and we'd just like to pick up parts of his summary. The court must conclude on the whole evidence that a refusal of a freezing order would involve a real risk that a judgment would remain unsatisfied. Bare assertions that a defendant is likely to put assets beyond the claimant's grasp and is unlikely to honour any judgment or award are not enough of themselves. Exiguousness of the claimant's evidence on this aspect must weigh strongly when the court comes to considering the matter inter partes. There must be solid evidence of the risk of dissipation. The mere reliance on the dishonesty of the defendant is not itself sufficient to found a risk of dissipation. If it is appropriate in each case for the courts to scrutinise with care whether what is alleged to have been dishonesty in the person against whom the order is sought in itself really justifies the inference that the person's assets which he is likely to dissipate.
Yeah.
The claimant claims that the KRG has been guilty of delay by seeking to assert state immunity. Whether or not the court upholds the KRG's position on state immunity, we say that a bona fide attempt by a state entity to assert state immunity cannot be considered an attempt to frustrate proceedings. If we are legally entitled to state immunity, and the court will decide that, then exercising a right which we are legally entitled to exercise cannot be characterized as evidence of a desire to dissipate our assets. At the very least, it is arguable that the KRG has state immunity, and so we say the court should not take that into account. There are a couple of rather detailed matters that I'd just like to deal with, but I can deal with them quite quickly. They relate to paragraphs in my learned friend's skeleton. If you'd be kind enough to turn to to paragraph 168. So at 168, it is alleged that there was a campaign to delay enforcement. It said the tribunal originally made its interim order on 10th July and its peremptory order on 17th October. Peremptory order, a small fraction, has still not been paid in full. We submit that the claimants are giving less than the full statement of facts. Then, the reason the peremptory order has not been enforced is in fact the claimants are being paid in stage payments under a memorandum of agreement and have agreed not to take enforcement action while they are receiving such payments. Having agreed not to take enforcement actions since March 2016, they cannot say that delay in further enforcement somehow establishes an intention on the part of KRG to dissipate its assets. There is also reference to press statements of Dr. Hawami that the claimants rely upon at paragraph 171 of their skeleton. We submit that they are irrelevant and indeed taken out of context. There is a well-known dispute between the Kurdish authorities and the Iraqi authorities, but this predates the date of the award, and I won't take you to it now, but footnote 60 to Mr. Benson's second witness statement shows that the press reports from which the claimants quote date back to October 2014 and November 2015 and relate to steps taken before the second partial award was issued. And they relate to steps the KRG was taking in relation to exports, which the KRG believes it is entitled to make under the UAE constitution. It is nothing at all to do with dissipation of assets to avoid payment to the claimant. Paragraph 178 of my learned friend's skeleton suggests that it was stated by Dr. Hawami that he expected to repay lenders $3 billion during the course of 2016. That is, in fact, a misquotation. what he was actually reported as saying was, one sees that in the press article which is referenced, he hopes it could be paid back, or at least significantly reduced over the course of 2016. He did not say that the full amount would be paid over 2016. But we say ultimately that the claimants are not entitled to go on a general fishing expedition at this stage in the proceedings. There must be some evidence of assets, we say, that would be within the jurisdiction of the court. An unsupported assertion that one of a list of entities may owe the KRG money and may hold assets in Dubai cannot justify the order that the claimants seek. And certainly we would argue that it's entirely inappropriate for any order to bear a penal notice, particularly since no penal notice could be enforced against the KRG in any event. So, my Lord, essentially we say this is at the very least a premature application, but we also say that one has to examine whether or not, even if so advised, a freezing order would be made in this case. It takes us back, obviously, to, as my learned friend recognises, to the issues before the court in terms of immunity. But it also takes us to questions which will have to be ventilated, no doubt, in due course as to whether it's appropriate at all, and whether it's within the power of the court to make a freezing order in these circumstances. So we say, my Lord, that this is a matter essentially for another day. Unless I can assist my Lord further, those are my submissions.
Thank you very much, Mr. Black.
Your Honour, I don't have anything substantial in response in reply on the disclosure application. I would just point out, my learned friend referred Your Honour to Article 59 of the law of the Union Supreme Court, which is about this reference of any dispute between or conflict between treaties, and then there's further reference to Article 33. My learned friend said, well, that's not new. It is new. That was the first time it's been relied on in these proceedings. So you won't find it in the evidence, you won't find it in the skeleton argument, or indeed in its application notice or in his submissions. So this idea that a conflict of treaties should be referred just isn't raised. That's the first time.
The conflict between treaties was raised the first time my learned friend's submission. The conflict between the New York Convention and the Riyadh Convention was raised the first time in my learned friend's argument. So I'm perfectly entitled.
Where are we looking at?
In the law. So
In
the Union Supreme Court law, or
yes,
the application. Sorry, the Union Supreme Court law is in G1. 24. Thank you.
G1.
24. So if we start with the Constitution, perhaps that's the best way just to bottom this out. If you go to tab 23, look at Article 99, Federal Supreme Court shall undertake deciding on the following matters. That's on page 15.
Yes.
And then your Lordship was referred to, under the heading of the Constitutional Courts, the Federal Supreme Court's jurisdiction, sub-articles 3, 4, 7 and 8. That was what was relied on. So I think what's now being said, well, I'm not sure quite what's being said, but then your Lordship was taken to Article 151 on page 22,
yes,
which is all about constitutionality. And that's where it was put, and then the provision that was relied on in the Union Supreme Court law, which is in the next tab, was Article 58, which is, again, the provision about constitutionality, and all of that authority about Fisk Firm and Barclays Bank and SR and so on is directed at that. And now we have, well, actually, there's a right to refer under Article 59, and And by the way, Your Honour should look at Article 33 in relation to this. Now, none of that is in any of my learned friends' submissions. That there is a conflict between the treaties which needs to be deferred. And of course, my primary case is that there isn't a conflict between the treaties. So one doesn't get to that route at all.
Nice of you.
If it's been said that it was argued as under that's not my recollection. No doubt there's a transcript, but I had it clearly in mind that what was being argued was Article 99 of the Constitution, Article 151 of the Constitution, Article 58 of the Union Supreme Court. That's the way it's been put consistently throughout in the evidence, the skeleton argument, and indeed in my Lord Learned Friends' oral submissions. But in any event, my primary position, there's a question about whether or not treaties are simply implemented into DIFC legislation. Your Honour said that doesn't work. My position is they're not implemented directly. There is, of course, a provision in the... So there's a saving for this court, for this jurisdiction, where civil and commercial laws are disapplied. And that was why I took your Lordship to the Barclays Bank case, which said even matters reserved to the Union are disapplied. That was the position there. Then there's the provision in the Article 42 of the arbitration law, which deals with the implementation, in effect, of treaties dealing with the enforcement of judgments. So then there's a question as to which aspects of those treaties are to be implemented, which aspects of those treaties this court is to follow. There's no conflict of legislation because that is a single provision that needs to be interpreted. So I just flagged that point for Your Honour. I don't have a right to reply to other friends' submissions, but that is new. Your Honour, I wasn't going to say anything further in response to the disclosure application. I made my application in relation to that. I don't need to repeat myself. If there isn't anything further that I can help Your Honour with.
Just bear with me.
Yes,
Okay.
of course. Looking for how it's put in the various different places when I can possibly assist with that. So, for example, in the skeleton argument, it's put in paragraph 52. And the provisions that relied on are set out in paragraph 32 to 35.
Yes, it was. I wanted to just ask you about tab 26, GG 126, Federal Law Number 8/2004.
Yes. Federal Law 8, yes, Your Honour. So it's, yes. So Article 3.2.
3.2 is what
disapplies.
Disapplies.
Yes.
But Article 5 specifically requires compliance with international agreements.
Yes.
So how does that work in the context of your argument that the treaties are not part of the law of the DIFC?
Yes, I mean I can see the difficulty. It's not a provision that I like to take your lordship's point on that. To that extent, it
So
requires compliance, albeit
the question which arises then, in looking at Abelard,
yes,
is whether or not Abelard is of application in a context where the treaties are part of domestic law.
yes, and that's not a question that's answered in Marachais or Abelard. That's fair.
Yeah.
I think that there's obviously the prior question of the interpretation, given that they need to be interpreted consistently. But yes, it is therefore a different situation. I accept that. The question, though, ultimately, yes, I can see it makes it more difficult to escape from the mandatory terms of the treaty. But as an attempt to preserve a consistency between the treaties in Article 6, one sees that. But ultimately, one ends up with a position, if it's right. My learned friend tried to answer your Honour's point, which is, well, yes, one can refuse to enforce on the basis of public policy, and one can see how it would be arguable that if there isn't an immunity, that would therefore give rise to a defence. But the question, the problem, in this case is different, because it arises if there is no immunity, but it's simply being asserted.
Yeah.
And then the question is simply, is it right that this court would be complying with the convention, or the New York Convention, if it was somehow required, well, if it refused to entertain the case. And so the first way around that is to try to find a way of making them work together. And that, in my submission, the only way of doing that is by adopting my submission. Now, my learned friend said in his submissions that I accepted that the terms of the Relay Convention were mandatory. I didn't.
No.
Well, unless I can assist you any more.
Yes. All right. No, I think
We've done enough of us.
more than enough
Yes.
for one day. Thank you both very much indeed. You'll supply what you can.
Yes.
In fairly short order.
Well, it has been supplied in part already. We've given the Arabic to my learned friends. I'm fairly confident that we will have a translation tomorrow. If we do, happily, I don't leave until the afternoon, so I can draft some very short submissions. And I'm fairly hopeful we'll get everything out tomorrow, before lunchtime.
I will do it as fast as I can, and I wouldn't have thought there's need for a time limit from my side. I'll try and do it on Friday if I can, but it might not be possible.
No, well, I expect to be back in London by just after lunch tomorrow. Do I interrupt? Yes, I do. After lunch tomorrow. So you can send it direct to my chambers electronically and to the court, obviously.
Thank you.
Yes, all right. Very good. Thank you all very much indeed.
Thank you.
All right.